Thank you, and it's very good to see you all again. I know we've had a number of engagements over the past year, so it's good to be able to engage once again. You have, I think, again, heard from a number of different witnesses from a number of different angles on the scandalous delays in our criminal courts. And I think as circuit leaders, I expect you agree with me that something needs to be done to address it. I'm particularly looking at Claire because I know the problems are especially acute in the southeast. I'm right about that, aren't I?
Yes, and we agree. I agree. Something has to be done.
And no doubt you'd also welcome the investment the government's making in terms of uncapping sitting days and thereby removing the financial limit on how much you and others can sit in the Crown Court.
Absolutely. That is something we have wanted for a very long time now, because that would have seen an immediate effect before now.
And you'll have seen the conclusion of the independent review of criminal courts, that notwithstanding maximum investment and efficiency measures which doubtless need to be taken, that those two things alone are incapable of reducing the backlog, aren't they? That's the evidence of the independent review.
Well, we don't necessarily agree. The difficulty has been that the sitting days have been cut, not just under one government, but more. The Nightingale courts that were dealing with the bail cases, that are the ones at the end of the outstanding cases that we have, certainly in London and the South East, they were closed. I think we have one that's just been made permanent, thank you, Chichester. They were there, and that's what kept part of our outstanding cases under control.
Well, I understand that you don't agree, but I don't understand that any of the circuits have produced independent evidence of their own to suggest that that conclusion is wrong, that we can bring down the backlog without some form of reform. I understand you disagree with the reforms the government is pursuing, but I don't know that I haven't seen any evidence that it can be reduced absent reform from the circuits.
Can I just deal with this? Because the reality is we've not actually been able to do this because there's been this consistent cap on sitting days. Judges have not been able to open up court days. They've not been able to run blitz days where they can really take hold of a case and shake it and say, right, what's going on? We haven't had any great directives to the CPS to say when you're charging these cases, you need to review these very thoroughly. And throughout this entire time, the criminal bar and the entire justice system is being brought down to its knees. So if you're saying, is there any empirical evidence that this has or doesn't work on your circuit, Ms. Goodwin, we haven't been able to do it. Now, what I can point to, and if I could just finish with this on this particular point, are courts where they have taken over, please, where they have been able to open up another court, and they brought in 300 extra cases, which is really important, 80 of those as Rasso. And the example I'm going to give you on my circuit particularly, at the coalface, is Teesside. Newcastle's also been able in the last 6 months to open up one more case, and the reality is all their Class 2 cases, which are these very serious cases dealing with sexual offences, are now listed within their time limits. So if you want to see if there is a change, it's happening now. So you've just got to let us do it, which I accept. May I make this very clear? I do acknowledge that you've finally lifted up the cap on the sitting days, but we need it consistently. So all of these, you can twist all these figures round however you want to, but you've got to let us try.
So just one final point, and I'm happy for each and any one of you to come in. There's certainly no twisting of figures. These are figures produced by an independent review and government modelling. But you're absolutely right. There needs to be maximalist investment, which is why we've uncapped sitting days. I entirely agree, and there are some excellent models from Liverpool and elsewhere of blitz courts, and we're beginning blitz courts in London and the South East as of April. But the conclusion of the government's modelling and the independent review is that those things alone, vital though they will be, can't do this without them, will not bring down the backlog. There is no other evidence, is there, that the backlog can be brought down without some form of reform, is there?
The difficulty is that we don't necessarily accept the time saving or the assertions as to the time saving. So let's take at face value the assertion that there's a 20% time saving. That takes a 5-day case down to 4. But you've got clause 5, which says that the judge has got to produce a judgment as soon as is reasonably possible thereafter. When is that going to be written? You know, that's your 5th day, isn't it? Because that's what the judge is going to have to do on that day.
Can I answer the lack of evidence? Forgive me. Wood Green Crown Court is a prime example. In August 2023, Harrow Crown Court was closed. It's still not reopened. In fact, it reopens on the 13th of April due to the state of the building. The consequence for that was Wood Green were using Hendon magistrates as full Crown courtrooms. They got their backlog down to just below, I think, or just near to pre-COVID levels. When Harrow closed, Wood Green lost those 4 Crown courtrooms because, of course, Harrow had to function somewhere. And so the consequence was Wood Green's backlog goes up. That's just a simple example of what extra court space does. Maidstone has been listing into Southwark and into Woolwich. That's been ramifications for Woolwich and Southwark because they've lost courtrooms. But just giving them more court space, they have reduced their lists as well. So that's without any other efficiencies. And we say the efficiencies must be tried first. For example, the trial I'm in at the moment in Winchester, prisoner escort have not managed to really bring the defendants to court on time when they're in Winchester prison. Most of the trial.
Thank you very much. The Minister wants to come in very quickly and then to Lib Dem spokes.
Just finally to Ms Davis, if I may. You said efficiencies must be tried first, and that's been an argument that's been aired very widely. Do you have any sense of how long those efficiencies would take then to bring down the backlog? If we pursue all the efficiencies, which government is doing, and I've mentioned some of those examples, how long would it take if we pursued all those efficiencies plus maintained uncapped sitting days to bring down the backlog?
Well, we don't know because we haven't been provided with the data that the government have had. Yeah. We have consistently asked for the data.
In the impact assessment?
And we've not been... Well, the impact assessment does not provide data.
Yeah. No. Thank you. Lib Dem spokesperson.
Thank you so much. Thank you all for being here today and providing evidence to the committee. My first question is, could any of you outline examples for the reasons why Crown Court hearing time has dropped on average to 3.2 hours per sitting day? And when we look at that drop, is it anything to do with jury trials?
The answer, I think we would all agree, it's nothing to do with jury trials. What's happening is, due to a lack of sitting days, what has happened is judges are having to deal with more administrative matters, other hearings, before they begin a trial. Yeah. If, of course, any of those are in custody, if there is a delay, because they're not always delayed, of course, that pushes matters back. And so a trial will take longer when, in fact, they're not having the whole day available to them. They're not having 10 till 4:30, which, of course, at the moment is the court sitting day. They're getting only part of that day. And so that's what eats into the hours, or one of the reasons.
Okay, thank you. And I would love at some point to talk you through the amendments that I've put onto this bill, which does suggest fundamental reforms, but not by curtailing the right to jury trials. Could I just ask as well, it's probably quite a simple question, which means that we can move on, but do you believe the Crown Court backlog could be fixed without reforms specifically to jury trials?
Yes, I do. And I've already pointed out, I think you've got to allow us the opportunity to put into place very key and significant changes, which, frankly, senior judges have already identified as giving us an ability to get through this backlog. I think also what needs to happen is that the investigative stage needs to be got hold of, and that needs to have a coach and horses driven through it. And one of the big complaints we've been hearing about today, and it's a terrible complaint really when one thinks about it, is the extent of time it's taking from investigation stage through to Crown Court through to the final determination with the jury. All of those come about with efficiencies which do not mean you have to remove the right to a jury trial. Now, let's focus on those. Let's invest, and it's very commendable, and may I make it clear, it's very commendable that we have this large investment which has been put in, but firstly, it is actually bringing us back to where we ought to have been after the last 10 years where we have suffered significant cuts and we're there. There is a will from the judiciary, there is a will from the practitioners, and we've just got to be able to make it work. If you've got experienced judges telling you, I need blitz courts, I need more courts, let's open them, let's staff them, let's resource them, let's make them work.